Hello, great people. Welcome back to Global Happenings. Today, we're so excited to have you again. Something is about to happen in this country which may drag all the presidents of Nigeria from 1999 till date to the law court. And I'm telling you, it's going to be quite an interesting one because already court order has been sent out in respect to all this administration, and which means if documents are not fully presented, it may culminate into summoning some of these presidents who have been there before now. Talking about Obasanjo, Yaradua. Well, Yaradua is gone, so Jonathan will have to provide it. And then Buhari, with their ministers, they have to provide it. And it has to do with the loot of late General Abacha, which has summed up to 5 billion naira. Nigerians do not really know what it was used for. There had been no detailed explanation. You know how our government works. But right now, the court is demanding everything. I'm going to give you full details, those who are behind this lawsuit and what the final verdicts were. And according to the news, the Federal High Court sitting in Abuja in a landmark judgment has ordered the disclosure of the spending details of about 5 billion naira, $5 billion Abacha loot by the government of former President Olusegun Obasanjo, Musa Yar'Adua, Goodluck Jonathan, and Muhammadu Buhari. The court ordered the government of President Bola Ahmed Tinubu to disclose the exact amount of money stolen by General Sani Abacha from Nigeria, the total amount of Abacha's loot recovered, and all agreements signed on same by the governments of the former President Obasanjo, Yar'Adua, Jonathan, and Buhari. The judgment was delivered last week by Justice James Kolawole Omotosho following a Freedom of Information suit number FHC ABJ-CS 407-2020 brought by the Socio-Economic Right and Accountability Project (SIRAP). In his judgment, Justice Omotosho held that in the final analysis, the application by SIRAP is meritorious and the federal government, through the Ministry of Finance, is hereby ordered to furnish SIRAP with the full spending details of about $5 billion Abacha loot within 7 days of this judgment. Justice Omotosho ordered the government to disclose details of the project executed with Abacha's loot, location of such project, and the names of companies and contractors that carrying out the project since the return of democracy in 1999 till date. Justice Omotosho also ordered the government to disclose details of the specific role played by the World Bank and other partners in the execution of any project funded with Abacha's loot under the governments of former President Obasanjo, Yar'Adua, Jonathan, and Buhari. Justice Omotosho also stated that the excuse by the Minister of Finance is that the ministry has searched its record and the details of the exact public funds stolen by Abacha and how the funds have been spent are not held by the ministry. The excuse has no leg to stand in view of Section 7 of the Freedom of Information Act. Justice Omotosho dismissed all the objections raised by the federal government and upheld SIRAP's argument. Consequently, the court entered the judgment in favor of SIRAP against the federal government. Justice Omotosho's judgment dated 3rd July 2023 read in part that the failure of the Minister of Finance to write to SIRAP informing it of where the said information exists or to transfer the request to public office who has custody of such information is fatal to their case under Section 5 of the Freedom of Information Act. The minister cannot use a blanket statement that it was not in possession of the said records of about $5 billion Abacha's loot sought by SIRAP. The government failed to provide details of the projects executed with the money. It also failed to provide locations of the projects and the names of the companies and contractors that carried out or are carrying out the projects funded with the money. I hold that by the clear wordings of Section 7 of the Freedom of Information Act 2011, access to information about spending details of $5 billion Abacha loot was denied SIRAP by the federal government. The federal government has filed a 14-paragraph counter affidavit deposed to by Abba Sunday, litigation officer in the office of the Attorney General of the Federation, argued that Sirap's suit is frivolous as it has not shown that the government denied it the information it seeks. The federal government has also stated that Sirap has not established sufficient interest in its application. The government urged the court to dismiss the suit. For the sake of emphasis, position of local standing has been the ban of the citizens' advocates in the public interest litigation to query transparency and accountability in the governance in Nigeria. In a democratic dispensation such as in Nigeria, the citizens have been proclaimed the honors of sovereignty and mandates that place leaders in the saddle. The requirement is a serious fracture of the citizens' inalienable right to ventilate their grievances against poor governance vis-a-vis expenditure of public funds generated from their taxes. The sacrosanct provision of Section 1, Subsection 2 of the Freedom of Information Act, which has ostracized these disturbing requirements, has admirably remedied the harmful mischief appertaining to it. Clearly, Section 1 gives a person the right to access any information from any public institution in Nigeria. SIRAP is an organization registered in Nigeria and thus a juristic person. As a juristic person, SIRAP need not show any specific interest in the spending details of about $5 billion Abacha's loot to be entitled to the same. I therefore hold that SIRAP is entitled to the information on the spending details of about $5 billion Abacha's loot and need not show any specific interest in the information sought. The provision of Section 4 of the Freedom of Information Act is quite clear and mandates that public institutions or public officers such as the Minister of Finance, the Attorney General of the Federation and Minister of Justice must make available the information requested within 7 days of this request. In a letter dated 8 July 2023 sent to President Tinubu on the judgment and signed by SIRAP Deputy Director Kolawole Oluwadare, the organization said, "We urge you to demonstrate your express commitment to the rule of law by immediately obeying and respecting the judgment of the court." SIRAP's letter written part said, "We urge you to direct the Ministry of Finance and the Office of Attorney General of the Federation to immediately comply and release the spending details of recovered Abacha's loot as ordered by the court. The immediate enforcement and implementation of the judgment by your government will be a victory for the rule of law, transparency, and accountability in the governance processes and management of public resources, including the $5 billion Abacha's loot. By immediately complying with the judgment, your government will be demonstrating to Nigerians that it is different from Buhari's government, which persistently and brazenly defied the country's judiciary, and sending a powerful message to politicians and others that there will be no impunity for grand corruption. Immediately implementing the judgment will restore trust and confidence in the independence of Nigerian judiciary. SIRAP urge you to make a clean break with the past and take clear and decisive steps that demonstrate your commitment to the rule of law, transparency, and accountability in the governance processes. SIRAP trusts that you will see compliance with this judgment as a central aspect of the rule of law and essential stepping stone to constructing a basic institutional framework for legality and constitutionality. We therefore look forward to your positive response and action on the judgment. Join as defendant in the suit are the Minister of Finance and Attorney General of the Federation and Minister of Justice. Justice Omotosho granted the following order of mandamus against the Nigerian government. An order of mandamus is hereby made directing and compelling the federal government through the Ministry of Finance and the Office of Attorney General of the Federation and Minister of Justice to provide and disclose the following information to SIRAP: exact amount of money stolen by General Sani Abacha from Nigeria and the total amount of money loot to recover, and all agreements signed on same the return of democracy in 1999 till date. Details of the project executed with the recovered funds, location of any such projects, and the names of companies and contractors that carrying out the projects. Details of specific role played by the World Bank and other partners in the execution of any project funded with Abacha's loot since 1999. An order of mandamus is hereby making direct and compiling the federal government to do all of this. Wow, this is a serious one. And Obasanjo and the rest, I don't know what they are thinking right now, but the truth is, um, I think none of them really have a grip over Bola Ahmed Tinubu's government. And I think that if Bola Ahmed Tinubu wants to put back Nigerians in his mind, or put back his government in the minds of Nigerians, he would have just aligned with this demand and let us see the nakedness of looting by this former administration. Possibly, if that is done, there will be strategies or strategy adopted to deal with all of this. And at least for once, we will see our former president being called to court to defend all of this, at least with those who had served in the offices of Minister of Finance and the likes. This is a very serious demand, and I feel that the federal government should do something about it. At least this will stem any form of corruption that is being planned to be executed in